minutes early.
Good morning, everybody. This is Jeff Vastola
Way to start your day
to give you
by getting free legal advice.
free legal
This
advice.
is Vastola on the Law with your host, attorney Jeff Vastola, featuring 30 minutes of free legal advice. Call in now with your questions. 877-850-8585.
Good morning, my beautiful wife.
That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
That's me, and good morning, everybody. Thank you so much for tuning in to Vastola on the Law. I am Jeff Vastola. I'm here just about every Saturday morning at 7:30 to give you free legal advice. All you have to do is sit back and listen. If you want to be a part of the show, then you can call in. You just heard the number. It's 877-850-8585. For those of you that tune into the radio show every morning, just bear with us. We're trying to get through some technical difficulties that we're having with the link. So you may hear me cut out for several seconds at a time, but I assure you I am sitting here and I will be talking until 8 o'clock this morning. Good morning, my mom. Tuning in from Tennessee. Keep in mind that my advice is only good in the state of Florida because I'm only licensed in the state of Florida, but don't let that prevent you from calling in and asking me anything that you want, preferably legal related, but that's the way the show works. I'm here to give you free legal advice, and it doesn't have to be just the topics that I'm talking about. This is a call-in program. As you know, I'm doing the show by Facebook Live, and there is a person that I haven't talked to probably since high school. Tiffany Lytle. Good morning. How are you, Tiffany? I see your posts all the time. Hope you're doing well. But if you have a question of your own, feel free to ask me over the show, the radio, or type the question in Facebook Live, and I'll do my best to respond to your question. If I know the answer right here and right now, then I'll answer your question. If I don't know the answer, then I'll do the research I have to do and get back with you the following week so that you have your answer. You just have to wait a week. Now, here's the beauty of the whole thing. If you happen to miss the show, all of these shows are uploaded into my website, so you can go back to the library and find the show that you missed, where you were waiting for your answer, and you can hear the show as a podcast and get your answer. The website address, if you're interested, is vastolalegal.com. That's V as in Victor, ASTOLA, legal.com. I have a toll-free phone number that is forwarded to my cell phone constantly. And I encourage people to call me on my cell phone about anything at all. Again, preferably legal related and preferably having something to do with a case that I can help you with. But my offer for free legal advice extends beyond this show. So if you happen to call me on the cell phone with something that's not in my wheelhouse Monday through Friday while I'm doing my work, I'll do my best to answer your question, and I might even encourage you to call me during the show. But I am here for you if you have a question. 833-VASTOLA is the number to call. That goes directly to my cell phone, 24/7. Especially if you're in some kind of an urgent situation and you need to speak with an attorney right away, then feel free to use that number, 833-VASTOLA, which is 833-827-8652. All right. I'm also on social media, not very often. I'm finding it difficult to keep up with that stuff. I go in phases. I do a bunch of posting and then I'll be quiet for a couple of weeks. Then I'll do some more posting. It's just not natural to me yet. Probably because I'm going to be 50 in 2 weeks. So I'm a dinosaur when it comes to social media. I'm sure some of us can relate. My topics for today, because of course I have to keep talking until 8 o'clock, are the importance of documenting a scene. These are issues that come up during my work week, and so I figure somebody might benefit from what I have to say. But if you're involved in any kind of an incident where you think a claim might result, and this doesn't have to be you pursuing a claim. Keep in mind that this could be you defending against a claim. But if you're involved in any kind of an incident and you believe a claim is going to result or should result because of it, then the importance of documenting the evidence right then and there is really important, and it's becoming more and more important. And it's because of the law in Florida is not oftentimes favorable to the claimant. So I'm going to be talking about specifically issues of incident reports and surveillance video, which if you've never been involved in a claim before, you might just think that you're entitled to those things. But the truth is you're not. Under certain circumstances you are, but they're limited circumstances. And if the presumed to be defendant, the person against whom a claim would be made, knows what they're doing, they can make it so that you do not get a copy of the incident report, you do not get a copy of the surveillance video, and you do not get a copy of any of the photographs that they took to investigate the claim. So the purpose of this show is to educate you as a claimant, and also perhaps as a respondent, to see what you need to do to be preserving your rights. That's one topic for the day. That'll take about 5 minutes, I would imagine. And then I'm going to talk about Governor DeSantis has allowed the moratorium on Florida evictions to expire, but that doesn't necessarily mean that if you are a tenant, you are without any protection, because essentially what he did in making his decision not to renew the moratorium was he is now deferring to the moratorium that is set forth in the CDC's guidelines, which he then adopted. So there is still an eviction moratorium in the state of Florida, but it's following federal guidelines through the CDC's order, as opposed to Governor DeSantis's statewide moratorium, which is it's a little bit different. And then lastly, if we have the time, a part of my agenda is to talk about qui tam actions, which is Latin term for the whistleblower type claims. So, and most importantly, your questions or your comments, even if you don't have a question, if you just want to be a part of the show with a comment, then feel free to chime in. The number to call in. Go ahead, Sharina. I'm sorry, Sharina, I didn't hear you.
You're cutting out really bad.
Oh, I'm cutting out really bad is what Sharina, the board operator, is telling me. Yeah, so if you're listening via the radio show, 8:50 a.m., just bear with us. We're going to have to try something new, because this new technology that we've been using for the past several weeks is apparently not working out. But if you are listening on the radio show and you can hear me despite cutting out, call me at 877-850-8585, and we'll do the best we can to get you on the air and have some dialogue. What I was going to say is, though, whistleblower claims, I'll be talking about that very, very briefly if I have the time. And also some select cases taken from the Florida Law Weekly that I get and I peruse every week. And topics for discussion. So let's just talk about the importance of documenting evidence at the scene, because this is something that becomes important only...
I have Don talking about UN.
Oh, great. Let's talk with Don. I was actually expecting this phone call because Don emailed me at the end of last week's show. Good morning, Don. How you doing?
Good morning, Jeff. How are you?
I'm doing just fine. So you mentioned you had a question about the UM
Yes,
insurance.
can you hear me?
I can hear you, yes. Go ahead with your question.
Yes, sir. I'd like to know if it's advisable to have UM and underinsured at the same time.
All right. Well, the UM is the acronym for uninsured and underinsured. Oftentimes it's the acronym for both. So the short answer, Don, is yes. And if you were listening last week, you know one of my soapbox topics is insurance, and specifically uninsured or UM motorist coverage. But yes, the short answer is yes, absolutely do it. Uninsured coverage would kick in if the person responsible for a crash doesn't have any insurance at all, meaning they have no bodily injury coverage in the state of Florida. But underinsured coverage would be if the driver that causes the accident that injures you or causes you some kind of economic harm has a little bit of coverage, but not enough. So oftentimes what you see in Florida are drivers that carry $10,000 of bodily injury coverage. So technically they have some, but oftentimes $10,000 is not nearly enough. So if you had uninsured motorist coverage, or if they called it underinsured motorist coverage in that scenario, you'd be protected either way. So thank you for calling, Don. I appreciate the follow-up. And yes, the answer is, when it comes to automobile insurance, first, make sure that you educate yourself and you know what the coverages are for. Secondly, don't reject coverages just because you're being told flippantly you don't need that. The state of Florida only requires 2 different types of coverage, and the other optional coverages are incredibly important. So third, my general rule is get as much insurance on your automobile policy as well as your homeowner's policy, any other type of insurance that you can afford. That's basically what it boils down to. All right? And I realize, Don, that the radio show is cutting in and out. My apologies for that. Hopefully you heard all of that. Do you have any follow-up to that? We may have lost Don entirely. That's a bummer. Well, Don, last week I was able to see you on Facebook Live, so hopefully you can chime in via Facebook Live. But I'm kind of wondering if my Facebook Live connection is still active because nobody else has chimed in. Normally I see quite a few people saying good morning, and nobody has chimed in since my friend Tiffany from high school. But I'm going to keep talking anyway. So the importance of documenting a scene. What you may not realize if you've never been involved in any kind of an injury claim in Florida is that you're not automatically entitled to get a copy of the incident report unless you either fill out a portion of the incident report yourself with your handwriting, or if you sign it. That's the second way that you could be entitled to get a copy of the incident report. So if you have some kind of a situation and an incident report is going to be filled out, insist that you be given an opportunity to fill out a portion of it or that you sign it, because if you don't do either of those things, then you won't be given a copy of it later on. Even right there at the scene, there are some companies that train their employees not to give the customer a copy of the incident report, even if it's asked for right there at the scene. So that's one way to preserve your evidence. All right, so you've learned a little bit of something today. Now, when it comes to the surveillance video, understand that a premises owner does not have to give you surveillance video just because it captured you or the incident and your injury. When you are in a public setting, you have no right to privacy, meaning you cannot insist that somebody not take pictures of you or that a store not take surveillance of you. And just because surveillance video captures you doesn't mean that all of a sudden you have a right to it. What you have to do is, first of all, if you're involved in some kind of an incident where you believe surveillance captured the scene, you have to request it very quickly, because oftentimes surveillance video it loops over, meaning it records over itself within a short period of time. It can be 24 hours, 48 hours, 72 hours, but at some point, most surveillance is going to record over itself. So if you don't request that they preserve it, and if nobody was there to realize that anything happened, then the video likely can be recorded over and nobody's at fault for that. Now, oftentimes, surveillance video captures an incident and it's preserved, and you might think, okay, well, I want that. I want a copy of that. Well, just because it captured you and your incident doesn't necessarily mean that you're going to get a copy of it. The law in Florida does not allow the owner or the lessor of a premises to give up the surveillance video just because you're in it. This may sound quite a bit skeptical, but what I've found is that oftentimes when the surveillance actually helps defend the claim, that's when the insurance company or the defendant, if a lawsuit is filed, will actually disclose the surveillance and share it, because it's helpful to them, because in the state of Florida you have a burden of proof, and if the surveillance video is going to help them defend. For example, in a slip and fall case, if you slip in a puddle of water, you have to prove that the premises owner either knew that there was a puddle of water there and just didn't clean it up, or what we call constructive notice, it had been there long enough so that they had an opportunity to inspect the floor and take remedial measures to clean it up. Well, if the surveillance video shows that a customer spilled a cup of water in an aisle, and then 30 seconds later you came by and slipped in that puddle of water, and there's no employees or anything in the vicinity for those 30 seconds before you fell, I hate to tell you, but that's going to be a summary judgment for the defendant, for the store, because you can't prove actual notice because there was nobody in the vicinity of the spill before you fell, and you're not going to be able to prove constructive notice because the condition on the floor was not there long enough to allow the store to find out about it and to clean it up. So that's a situation where probably very early on, the store is going to share its surveillance video with an attorney to say, look, you might as well just shut this one down because it's not going anywhere. And any lawyer that has experience in this field and knows what he or she is doing is going to have to sit with the client and say, look, we bear the burden of proof, and this is the law in Florida. It's a very, in my opinion, a very unfortunate law. but it's there, and when we have to deal with it, but you're not going to be able to prove your case. You're not going to win this one. So that's oftentimes where you'll get the surveillance video very quickly. Now, there are times when you will not get the surveillance video, or perhaps you have to make it's a fight. And then sometimes it's within the court's discretion as to whether they're going to share the video, despite the objection from the defendant, because of an argument that you can put forth. Specifically, does it identify an employee when the store says, oh, I'm sorry, we can't identify any of the employees that were in the vicinity? If the surveillance video actually depicts somebody, then you might be able to get a copy of it that way. And there are ways to go about, sometimes getting the surveillance, even if they don't want to share it. But this topic was the importance of preserving evidence very early on. So it's not just a matter of, an incident report or a surveillance video. It's important to request those things early. As I mentioned, sign or fill out a portion of the incident report if you can. Request video as soon as you can, but also photographs. It's very, very, very common in automobile accidents to have skid marks at the scene of a crash. But especially with the rains we've been having lately, skid marks will disappear. They can disappear very quickly. So if you feel that there's evidence at the scene that's going to help your claim, then even if you can't do it right then and there, then go back. Go back and document the scene. There's nothing wrong with doing that. Just be safe when you do it. Obviously, you don't want to stand in the middle of the road while you're taking pictures of skid marks. But it's those types of things that will help your claim later on. And as I said before, the reverse is also true. If you are a premises owner and somebody falls in your store, document, because there are frequently claims that become very difficult for us to prove. And I'm a plaintiff's lawyer, so I represent the person that's injured, but very often I find it difficult to prove a case because the scene was documented so well by the premises owner. So I don't mean to come across so one-sided. Documenting your evidence can also help defend your claim if you are the owner or the lessor of a premises, or if you're involved in an accident and you suspect that the other person is going to somehow be blaming you for this, but you don't think it's your fault and you believe there's evidence at the scene that would prove otherwise, then document the scene. I assure you, your lawyer is going to appreciate the fact that you have that stuff to share. So, moving on from that topic, and again, I know we're probably cutting out quite bad on the radio show, and I apologize for that. I saw my mother chimed in and said, apparently the Facebook Live feed is still working, so good morning everybody that's watching by Facebook Live. In the event that you live in Florida and you're concerned about a residential eviction, the coronavirus, it's not so novel anymore, and unfortunately people are kind of getting into a new routine, I think, but a lot of people have been truly affected by it, unable to work or have lost a job, and the governmental assistance that was offered in the beginning was great, but it's gone, and there's suggestions that there won't be any more governmental assistance, and the reality is that people are finding it hard to pay bills or impossible to pay bills, and landlords at the same time are finding it very difficult to pay their bills because they're not getting the rent from tenants. If you're a landlord, this is a very difficult time for you. We understand that. So leading up until October, the state of Florida, through Governor DeSantis, had imposed a moratorium on residential landlord-tenant evictions. But that expired on October 1st, and the reason it expired, at least statewide, via Governor DeSantis, is because he elected to go with a federal moratorium, which was set forth, propounded by the CDC, using the facts and the science of the coronavirus to substantiate that people shouldn't be evicted in this particular time if they can prove certain things. So here's the point. There is still a moratorium on residential landlord-tenant evictions in the state of Florida, but it's not just exclusive to the state of Florida. It's throughout the entire United States because of this CDC ruling, which I thought was pretty interesting because the CDC, the Center for Disease Control, I wouldn't think would have the authority to issue an order saying that you can't evict anybody, but I believe that it does have authority because it was somehow adopted by President Trump or the government, the federal government. But you must proactively adopt this moratorium on an eviction if you want to try to use it. Because what's happening is, at least the statewide moratorium did not prevent landlords from filing eviction proceedings. It just prevented the eviction proceedings from going forward if the defendant, meaning the tenant who is being evicted, defended himself or herself and set forth all of these things that have to be set forth. I lost my job because of the virus, I can't pay my bills, that kind of a thing. In reading through the CDC order, although I read an article in the newspaper that says that the CDC order also allows evictions to be filed and the defendant then has to set forth all of the defenses that are set forth in the moratorium, I also read through the entire order from the CDC, which is very lengthy, and it actually provides criminal penalties against a landlord if they bring a moratorium. I'm sorry, I just got distracted because somebody chimed into Facebook Live. Good morning, Delita. Nice to see you. But criminal and financial penalties if a landlord brings an eviction proceeding in violation of this moratorium, which I thought was very interesting and which is why I thought that I might discuss it. So, in the event that there are any landlords out there and you're kind of wondering to yourself, am I really still allowed to file an eviction? I would strongly suggest that you go to the CDC order, which you can find online very easily. Just type in CDC eviction moratorium. Hi, Patty. Nice to see you. And I'll be talking to you later, Patty. I sent you an email yesterday about one of our cases, but review it, because what you don't want to do is get yourself in trouble. I mean, being in trouble financially is one thing, but getting yourself in trouble criminally because you filed an eviction when you weren't supposed to, that could be a mess. So just be very careful if you're a landlord right now. And good morning to you, Delita. So let me talk about a couple of cases in my Florida Law Week, because the last several weeks I haven't been able to get to these things because I keep talking about other stuff. I found this case, which I thought was interesting. It's a case out of the 2nd DCA, which is over there in the Naples, kind of Sarasota, Tampa area. It's a divorce case. It's street versus street. And the ex-married couple were fighting over what are marital assets. And you can tell this is a wealthy couple. They were talking about cars and boats and a boat slip and all these other things that they were fighting over. And the trial court issued a ruling after the divorce trial that the husband had to pay the wife within 60 days $952,000 plus. All right, so they're fighting over a lot of money and a lot of things. Well, the ex-husband took the appeal and said, well, wait a minute, I think the trial court made a mistake here, because a lot of the things that the trial court said I have to share with my ex-wife are things that I had before the marriage, or they are things that I bought during the marriage, but with money that was not joint money. It was money that I had before the marriage. And so I just thought I would point this out to anybody that's interested in what is a marital asset. So Florida statute sets forth, it's Florida statute 61, but the law in Florida's equitable distribution in the statute provides the following. Marital assets and liabilities include A, assets acquired and liabilities incurred during the marriage. So it's not just assets, but it's liabilities, debts also, individually by either spouse or jointly by them. And it also includes B, the enhancement in value and appreciation of non-marital assets resulting from the efforts of either party during the marriage or from the contribution to or expenditures from marital funds to increase those values. And then letter C is the interspousal gifts during the marriage. So of course, if you give your spouse a gift, then it's going to be a marital asset. Non-marital assets and liabilities include assets acquired and liabilities incurred by either party prior to the marriage, and assets acquired and liabilities incurred in exchange for such assets and liabilities. Number 2, assets acquired and liabilities incurred, assets acquired separately by either party. Thank you, Sharina. by non-interspousal gift, bequest, devise, or descent, which is sometimes inheritance, and assets acquired in exchange for such assets. So essentially, what this ex-husband was able to prove, and he won on appeal, that because a lot of these things were non-marital assets because they fell into one category or another, he was not going to have to pay his wife the $950,000 within those 6 months. So thank you all for watching and listening. If anybody wants to talk to me off the air, dial 833-VASTOLA. That's 833-827-8652. Everyone have a great weekend, and God bless. Bye-bye.